off, first of all, by apologizing for something that I didn't know was happening until after the last meeting last month, which was, they put the time for this meeting in my calendar 15 minutes after they put the time on the calendar for everybody else. And apparently that had been some sort of tradition. It isn't going to happen again. Consequently, I would walk in late not knowing I was walking in late. I'm walking in early. Is there a motion to adopt the minutes from the previous meeting, or any questions or changes or alterations, corrections, whatever?
Motion to adopt.
Abstain.
It's adopted unanimously with one abstention. Oh, that might be an oxymoron. Helena Bolson is going to brief you on our efforts to create a universal summons. I don't want to use the word universal summons too much because that will get confused with the police department's use of the word universal summons, which is a criminal court summons. But as Helena will explain, one of the things we've discovered in reviewing stuff for in the last few months is that there are a zillion different flavors of summonses that are issued and are returnable to us. One agency in particular has, I think, 35 different flavors of summonses. That is incredibly confusing to the public who gets a summons from one agency, then from another agency. They think they got, the first time around, they got the process down pat, and then they find out that it's a whole different drill. So Elaine, please.
Okay, so what we tried to do was make things as homogeneous as possible. And obviously, you know, as between long-form tickets and short-form tickets, there are going to be some significant differences. What you have before you are short-form tickets, but to the extent that some of the long-form tickets will look this way, it's really the back of the long-form ticket that's going to be different. So I'm just going to take you through the different fields. So the first thing you'll notice is that we are asking the agencies to put their logos at the top. Do you have this one?
It's just that there are two of them. Which
Yes, one is, okay, so one is a little one that we shrunk for sanitation.
Oh, okay.
Okay, and then the other is the larger one, which actually DOT is going to be implementing very shortly.
Which one are you looking at?
I'm holding up the bigger one, but you could look at either because that's the beauty of it. They're actually the same, okay? So we're asking the agencies to put their logo at the top. We're changing it from notice of violation to summons. If anybody's concerned about that, because the charter does say notice of violation, the board shall prescribe notices of violation. ECB's rules define notice of violation as a document issued by a petitioner to a respondent which specifies the charges forming the basis of an adjudicatory proceeding before ECB. So I think that the definition is broad enough that it can encompass the word summons, and we will be changing that when we do rulemaking later in the year.
Let me interject. The main reason for that is the way the language is structured. It sounds like we're telling people, you're guilty, come in and prove you're innocent, when you say notice of violation.
So then we have the agency name in a fairly larger font, whatever the division is, agency address and phone number. I know that there's been some, I don't want to say pushback, but some comment on agency address and phone number. Does it have to be there? It doesn't have to be there. You could put 311 there if you want. It's really up to the agency, but the field will be there, and some agencies do want to put it there. And remember, this is not going to be just for ECB. It's also going to be for the Health Tribunal, which will soon be the Hearings Division, and also for taxi.
And let me interject there again. In the last few months that I've been here, I keep on getting remarks from city councilmen or the public in general complaining the ECB is sending me all these summonses. for this, that, or the other thing, and I had to enlighten them that ECB doesn't issue summonses. Enforcement agencies issue summonses, ECB adjudicates summonses. So to clear up that confusion in the public, which seems to be pretty intense, the public should know who issued the summons. Right now, the current summons simply just has an agency code, like Human Creation knows that 457 means sanitation department, or 568 means police department, or whatever. They'll know clearly that the summons was issued by a sanitation inspector or DEP or whomever, and they can complain to them instead of to me.
Okay, the next set of fields concern the respondent, and who the respondent is, the name. If the respondent has a DBA, that can be filled in. It doesn't have to be filled in. The respondent's mailing address, which we have on all the summonses now. Any ID number that's used for the respondent, so it could be a vendor license, it could be a permit number, depending on the issuing agency. The type of ID and who issued it. Again, not all of these have to be filled in, but obviously there does need to be a named respondent. The next set of fields is about where and when the violation occurred. The start and end times of inspection actually is more for the health tribunal. For the issuing agencies here, it would just be whatever the time that you put on the NODs now. And then we have the hearing date, and it was really important to me that the hearing date be large, in the middle, easily recognizable. We do want you to spell out the month in your electronic summonses if you can, because let's face it, not everybody is from here, and there are some cultures where a month comes before day and day comes before month. So I think spelling out the month would be very helpful for our population that comes here. The hearing location, instructions, and then the summons number is going to be there too. And then underneath that field, we moved up the warning about what happens if you don't appear. It had been buried sort of near the bottom of the summons, so we made that a little more prominent. I know the font is still fairly small, but at least it's in its own location and not sort of buried in other text. And then we have the details of violation, and I've been referring to that as the agency real estate. So that's where you can put in whatever you want subject to ECB IT. You will need to put in sections of law, obviously. You'll need to put in computer codes. I know that the building summons and sometimes the fire summonses have a lot more information. You have block lot, you have the type of property, you have the date of inspection, et cetera. So you can put in whatever fields you want in that real estate. Yeah.
So Ronaldo from building, but this form is not going to be used, the long form, right? This is a short form.
Well, the idea is to use this as much as we can for the long form as well. The problem with the long forms is that IT, the computer needs to know how many pages to expect when it's filed, so we kind of have to work through those issues. But for now, what we're presenting, because that's going to go live, sanitation is working on their ticket, we wanted the board to understand what it's going to look like. So we're not married to any of it. It's a prototype for now, for the short form. For the long form, we'll work through all of the issues.
I want to add, one of the reasons that this is laid out the way it's laid out is because this is essentially setting up for when eventually all the summonses will be generated in the field by handheld devices. And this makes it easier to transition to that format because the handheld devices will not be able to print something this big. If you've noticed, the traffic enforcement agents, when they're issuing parking tickets, they have a printer strapped to their leg, and to strap a printer to your leg that can print something this wide is going to require some very healthy folks.
Hence, we have this size.
Yes. Ernie Cavallo, citizen member. Helene, so if you have more than 4 violations on an inspection, you can't use this form?
No,
Is
you
that-
can. This field can expand, but it can only expand to the limitations of what the computer is expecting. So, how many violations it is depends, which is one of the issues with the long form, because you could have an elevator ticket that has like 20 different conditions on it. So that's one of the reasons that we need to work through the issue with the long form. But for most of the short form tickets, well, actually, all of the short form tickets only have the one charge. So for the short form, it's not really a problem, there's just gonna be the one charge. I think Joe,
Yeah.
Joe and then I'll.
Joseph Quinn, Fire Department. I noticed in the, you have in the section details of the violation has compliance date, and you changed that from cure date form, is that the other one that I had?
Again, this is agency real estate, so this is meant to be a more general version. You want cure date, you can write cure date.
Oh, you can write,
And you
okay.
should, yeah,
Okay.
you can write cure date, right?
Okay.
This is your area where you get to put in your stuff.
Except I think the cure date then should be prior or very prominently next to the hearing date. They should, because you want people to know that they can't cure in lieu of a hearing if that's available.
So the examples that I have for the fire and building departments don't have the cure date up on the top, but it is in those fields. You can make it larger if you'd like to.
You wouldn't be able
The
to-
instructions about how to cure are on the back of the notice of violation, and there is a statement, I think taken from the DOB violation actually, about you have a right to cure, et cetera, et cetera.
I just think that it's, you know, the cure, that if you want to let the public know that they have a zero penalty option other than the hearing. So it should, if there's a way to have a cure date in line with the hearing date, side by side, and say see below or something like that, it would be good for the respondent.
Well, that was the same thing with the fire department, because we're more interested in compliance as far as that goes, rather than penalty, excessive fine, and so forth. So one of the comments that we've had is that the cure date should be more prominent as far as.
Would the, say there's 3 or 4 violations like in the sample, would the cure dates be the same or would they be different for each violation?
Yeah, the agencies would only issue, would not issue more than, I mean, different violations, some are curable, some are not.
Right.
If they're issuing two violations, one is curable, one is not, then they would separate the violations. So they wouldn't have some. Because you have to do.
For buildings,
tickets, right.
for buildings, but fire,
Right, the
you
fire.
can have partial cures and it would all be on one notice
Right,
of
it could be,
violation.
I mean, if they only cure, if there was 4 violations and they only happen to cure 3 of them, then it would be a partial cure. And then they would have to come to the hearing for the outstanding.
Right, I think really the issue is, you know, the stuff in the center about the hearing date is really about oath, and the stuff in the details of violation is really about the issuing agencies and what's available. In terms of the short form NOVs, there's only one charge that's curable. So I'm
I
not
understand.
that concerned.
I understand, but I
for the
think you need
short
to be a little
forms.
flexible here, because it's not, you know, in terms of separating, I know what you're trying to do is separating oath and the agencies, but in this case, it's benefiting the respondent. And they should keep them in mind here, that if you, that major separation.
Yeah, my concern is I like the idea basically of where it says hearing dates, you can have an extra field that says cure date or something to that effect, but if you have like 3 violations and 1 is curable and 2 are not curable, I don't want to give the respondent the misimpression that if he cures 1, he's curing the other 2 and he winds up defaulting on them or something like that.
Which happens now.
That's the only thing that I'm concerned about, is that I don't want somebody to come in and say, well, it says cure date, and I cured it, but now you're telling me that on 2 and 3 I'm defaulting.
You know, and there's also the instructions about the cure, which is that, you know, it has to be received, et cetera, et cetera. So, and that's all on the back. It's going to be on the back of the
Are you
form
going to go over the
now.
back also?
Huh?
In your presentation, you're going over the back?
For the not for the no cure ones. We're not doing the cure ones today, because these are short ones.
Okay.
Okay? Yeah.
I had a couple of questions on the, Elizabeth now, our citizen member. I had a couple of questions on the warning.
Okay.
First, it says if you do not show up for your hearing, but you don't have to necessarily show up. So I wondered if that can be expanded to encompass the notion of hearing by mail or.
Well, showing up includes hearing by mail. I mean, it's an appearance, whether it's
Right,
an appearance
I
by
know,
mail or
but
by telephone,
it-
online, or in person.
But as a layperson would read that, it just suggests that you have to be there at that day and time.
So you would want it to be, if you do not show up for your hearing, either in person, by mail, by telephone,
If
or
just to make
online?
that, yeah, I think, if there's a way to do that, to make it clear, I would suggest that, because it actually might encourage people to do it by mail or phone, which we think we want.
I think that's a good point.
And then where it says, if you don't show up for your hearing, the summons will be decided against you and penalties will be imposed. Should we clarify that those would be maximum penalties? Or default? I don't know if default and maximum is always the same
No.
thing. It's not,
No.
you know,
Yes, that's good.
because I think, you know, people think, well, I'm guilty, but so I might as well not show up, and the penalties will be imposed one way or the other.
So higher penalties?
Higher, yeah, if we can clarify that, I think it would encourage people to come, so they won't, and then they won't be subject to the default penalties. The other question I had, what it says, your license may also be suspended or revoked. I would just suggest saying your license may also be suspended or revoked as applicable, just so people don't think it's their driver's license.
Oh, it could be their driver's license.
Well,
Let me just say that that sentence has been here for years. And I don't think that anybody's ever been confused about it. but-
okay, all right,
What I-
well,
what I- what I-
suggestion.
What I mean about the
And-
excuse me,
I'm
sir.
sorry.
What I mean about the driver's license is that in New York State, anyone who has an outstanding court judgment, a civil judgment, which ultimately can result from any of these, you send a copy of that judgment to DMV, they will suspend your license until you satisfy the judgment.
But that wouldn't occur just because you didn't show up for a hearing. It would have to be,
This would be post-docketing
Right.
and down the line if you haven't paid it. And it'll actually be not something that will be determined by oath. It'll be something determined by the Department of Finance, whether they want to push it to that level of collection.
but this is really meant to be referring to an operating license, right?
Well, yeah, like a vendor license, for
Right.
example.
Well, it's a suggestion, just so that it's something that occurred to me, but,
And also for abandoned vehicle tickets, I mean, we do actually notify Albany about the status of those tickets.
I mean, instead of saying your license, it should say your licenses.
or your license to operate, but I guess if it's an abandoned vehicle ticket, it can, I would just say, I would suggest saying as applicable,
But that doesn't have any meaning to a layperson. As applicable doesn't mean anything to them.
I think it would suggest to somebody that has an operating license that it applies to them. But if you feel like nobody's ever been confused by that language and.
As far as I know,
Okay.
nobody's ever been confused, that, you know, nobody's ever said,
I got a funny feeling most people ignore it anyway. I'm sorry to say.
I must.
all right, anything else on the front?
Yeah, Russell Pecunias, DEP. Just one observation and one comment. The observation, I noticed that this summons does not say Environmental Control Board on it anywhere. Is that by design?
Yes.
Okay. And the summons number, which on all of the existing NOVs that I'm familiar with, is fairly prominently displayed, seems to be very non-prominently displayed on this form. Is that by design, or?
You know, I
Usually the
think,
first thing you see, like on the existing short form ticket, is the big NOV number on the
which is on
bottom.
the bottom, right.
So is that deliberately being sort of made more obscure?
I don't think it was deliberate. I think it's not as important as it used to be because everything's barcoded now. And you'll notice that the barcode is there and is in exactly where it is now. That was the only thing that our IT people said. Make sure it's barcoded and where it is. So, you know, in terms of whether or not it needed to be as large as it is now, from our standpoint now, it doesn't have to be as large. If you think it should be larger, we can make it larger. I was more concerned with getting the hearing date, making that more prominent.
Well, that's true, but, I mean, the first thing you look at, and you're responding to a ticket, is you call 311, you call the agency, they're asking you for your number, your NOD number, or your summons number. You're looking at the very top, at any form, and I think no one at home has a barcode. Kind of thing. So, you know, you put it up top in probably big numbers. I don't think there's anything wrong with having, you know, making display the number, right? Properly involved.
Like opposite to where it says agency logo.
Right.
Or-
Well, that's in a header, so I don't know how easy that is to program, so.
Or if you put it
You know,
above the
Right out the
barcode.
summons for civil penalties.
You put it properly above the barcode.
That's what I was thinking about. There are some documents that I've seen that, where they include the barcode, and where and I don't know if the computer prints it out at the same time that it prints out the barcode. I think it does, is right at the same time that it's printing out the barcode, which is unique to each document, it also prints out in human letters what's represented in the barcode, which is the summons number. So, I mean, this may be a matter of programming. I don't know if it's going to cost the city another $500 million on this stupid little thing, like some of the stuff I've heard.
Well, the barcode, I think, has to stay where it is.
No,
but
the barcode-
The field summons number could
Well,
be moved anywhere.
What I mean is, as it prints the barcode in some printing together with the barcode, underneath the barcode or above the barcode, actually put that, you know, the Arabic number digits as opposed to the bars. I don't know if it's practical from an IT point of view or not, but I know I have seen it in some documents. I think I've seen it on some tax forms that I've used that have barcodes attached to them.
I just think it's kind of weird to have it in the middle.
Mhm.
Usually you're looking for it at the ends, it's, you know, where's my number?
Uh-huh.
And embedded in the middle.
Or maybe it should be printed in red.
Well, that's
The actual summons number printed in red.
costly.
That's close.
That's real costly. I mean, we could move it up, could we move it up to the top, do you think,
Top
Commissioner?
right.
Well, I wouldn't say top right, I would say above
Either-
issue and
either
agency name.
Just more prominent or larger, or some way to sort of make it more visible.
Let's check it out. I like the idea of this being on the top and bold, because I think it's true that people, when they first look at it, I know when I get a parking ticket or whatever, and I'm sitting at my computer to get rid of this stupid ticket, I'm scanning the only number that counts on that thing is the summons number.
So, Attorney Cavallo, citizen member, should it go under summons for civil penalty only? Should the line that says summons number be under that? Or refer to the following summons number and all correspondence and the summons number come right under that and everything else shifted
I
down?
like that, right underneath the summons number, the summons heading.
It says summons for civil penalty.
Yeah, right, no, I understand that. Madeline?
Madeline Labarde from Sanitation. I'm going to talk to my IT people. We were good with this format and we keep changing it up. I don't know how it's going to work with all this. That's my only concern.
Have you been told? You know?
Yeah.
Oh,
Yeah, that's why we have the reduced version. They needed a reduced version for their little.
Because you guys are doing electronic.
We have electronic for half of our guys. Our RCAs are all on standby and they have been for years.
Printing the summons number in red is bigger expense. Oh, we have red ink already for the warning.
It's small, yeah. Yeah.
would it need to have red ink, right, for warning?
I think it does actually have red ink now.
Then it wouldn't be possible.
Well, I don't know if the Novus ones have red ink.
No, well, they do because we have pre-printed summonses, but going forward, we're not, so everything's gonna have to be in black and white.
So much for that, David.
I'll change the warning to black and white, so, yes.
One question.
Robin.
Yeah.
Carver.
Carver, yeah.
Yeah.
Oh, sorry.
Correct.
Will the absence of the ECB name on the summons interfere with the ability to have a valid judgment? Because I'm thinking typically in a civil lawsuit, the judgment holder's name was on the summons, and here that this is not the case.
Well, it is on the back,
Like,
so,
I noticed it's on the back just for writing your check answer, right?
well, no, it says if you do not admit the charge, the independent New York City Office of Administrative Trials and Hearings will decide your case. It actually
Well-
doesn't say-
Doesn't say.
Well, you said the judgment holder?
Yeah, because I thought that it's under the ECB statute that we get a judgment under it. Is that not
If it's
correct?
served a certain way, yeah.
Oh,
It's not necessarily locked into the ECB statute as a docket, because we can docket summonses that are issued in the way the current structure is, hearings are divided into ECB tribunal, taxing tribunal, and health tribunal. At the end of the exercise this year, there will be no health tribunal, no taxi tribunal, no ECB tribunal. It will be just a hearings division. And the hearings division will be designated to hear cases that are returnable, quote unquote, to the Environmental Control Board. The actual judgment holders will be the Department of Finance, as it is currently, by the way. It's not an ECB judgment, despite what we hear in the press or in the city council. It is a judgment that's held by the city of New York. That's why it's collected by the Department of Finance. And the Department of Finance is the one that does whatever they have to do collections. Mechanically, what happens is if somebody is found guilty or pleads guilty to a summons, up to about 45 days, we will collect the money. That is, Oath will collect the money and then transfer it to the Department of Finance. After 45 days, when it's converted into a judgment, we have nothing further to do with it, and the Department of Finance proceeds to do whatever it does or doesn't do to collect it. It's none of our business anymore. So when you hear stories in the press that there are $1.5 billion in ECB judgments outstanding, it's not quite accurate. There are essentially no ECB judgments outstanding. It's really all judgments held by the city of New York. They may have originated at a proceeding at ECB, but they're not ECB judgments. One of the issues that we've been struggling with in disabusing people a lot of lately is that ECB is not an enforcement agency. It's an adjudicatory entity. It is, to say the least, highly inappropriate for us to be the enforcement agency and the adjudication agency at the same time. The whole concept of taking tribunals out of the enforcement agencies is that adjudication is done by an impartial and neutral entity. One of the scary things that's right now before the City Council is legislation that takes the Parking Violations Bureau out of the Department of Finance and gives it to us. Only scary in the sense that it will literally more than double our volume. Just as an optic, you walk into a Parking Violations Bureau and across the top it says Department of Finance. You might as well say Sheriff of Nottingham. and come in and plead innocent. What we're endeavoring to do is to, in fact, and in Imogen, and the attorneys in the room are aware of this concept more than anybody else, I think, because we have to live with it every day, that the appearance of something is just as serious as the actual fact. And if it appears that we, both ECB, are in bed with enforcement, it kills the whole concept that you're going to get a fair and neutral hearing. And a major piece of our exercise for the next 2 years is to absolutely divorce everything that Oath does from the mechanics of any other city agency. Part of the problem is as a result of when consolidations occurred, it was done very clumsily. And parts of agencies' functions that really were not adjudicatory were pulled in together, like collecting money for summonses and revenue and that sort of thing. That's totally inappropriate for a judicial tribunal or a quasi-judicial tribunal. You have a case in civil court and I get a judgment against you for whatever. It's not the civil court that collects the money, it's that there's a process where you, the plaintiff, collect the money, either by doing an attachment or by garnishing wages or whatever it takes, but it's not the court that does that. It's not the business of the court. The court does not make money on finding you guilty. I want to make it clear that we don't make money by finding people guilty.
Yeah, my notion that ECB was the judgment maker, which you're telling me is not correct, comes from reading title. Every title report gives you what they say, ECB judgments.
Yeah, that's something that's not only in those reports, that appears also in databases maintained by other city agencies, like the Department of Buildings, for example, but they have things called building violations, they have ECB violations and fines and stuff like that. That's stuff that has to be worked through, the granular stuff in the weeds that has to be cleaned up. And it creates a lot of misimpressions when you deal with the public. I've made it a point of going out and finding out what people think and what their understanding of ECB is, city council members, other people in government, never mind the general public. And you get an incredible feedback of misconceptions of stuff. They think, for example, that ECB does sanitation policy or DEP policy or even certain police department policies. We don't. We don't do any of that stuff. We don't write the sanitation rules or any of that stuff. But people believe that. I can't tell you how many times I've heard from somebody, you know, you guys are terrible. ECB is giving summonses to all these little old ladies for the recycling stuff in their little one-family homes, or for not cleaning up the snow after it snows. And I tell them, ECB doesn't give you any summonses. That comes from the fact that when you look at the summons form in Justice Environmental Control Board, it doesn't say sanitation department or whomever in the world is issuing those summonses. Even buildings department summonses issued to people who put up illegal signs. I get lobbyists calling me, complaining about ECB giving their clients summonses for having for violating the law by putting up signs on the building. And I said, you know, please call the building department. We don't give you the summonses for that, we adjudicate it. We gotta make it clear to everybody in the city and beyond. And I mean, by in the city, I mean even elected officials, that we adjudicate. That's all that we do. And part of the stuff that we're dealing with is a lot of legacy stuff. Once upon a time, the Environmental Control Board literally had the sanitation department working for it, it had the DEP working for it, and I don't know how many other agencies working under it. This is one of the Lindsay administration's super agencies. And as time went by and they realized that that model didn't make sense, they started chopping things out. And as they chopped things out, it was a lot easier to just do a surgical, clumsy cutout without taking care of the details. And what we're endeavoring now to do is to get in there and clean up the details and get rid of a lot of anachronistic stuff that just doesn't make sense 40 years later. And this is just one step of what we're involved in doing. We have a task force working right now with the Mayor's Office of Operations, the Mayor's Office, and pretty soon the City Council to get rid of a lot of this historic flotsam and make it clear to everyone what exactly is going on. And part of it is having consistent procedural rules across the board for all 26 city agencies that issue summonses every year. It just doesn't work that one set of summonses says you have a return date in 15 days, another one says you have a return date in 30 days. One agency gives us electronic summonses that we have within 24 hours, another one gives us paper summonses that isn't in the system for 4 to 5 weeks later, and somebody's trying to pay the summons and they can't, nobody knows how to pay the summons because nobody has a record of it yet. That's all stuff that hopefully at the end of the exercise won't happen, and everything will be automated and everything will be consistent and everybody will be clear that when they come to a hearing, that they will be treated on the same basis as the complaining agency. The agency will be the petitioner, a member of the public will be the respondent, and they will stand equally before the hearing officer with no special consideration or privileges to either one. And that's the goal. And this is just one little step in that process. End of speech.
Question? Or Ernie Cavallo, citizen member, can you go back to the top of the summons? Calling it a summons.
Yes.
I've been thinking about it, and I'm not sure how my colleagues on the bench would take an argument that we have no power to issue a summons. We only have power to issue a notice of violation. Did somebody run this by the law department, changing it from notice of violation to summons?
So let me just say that the Taxi and Limousine Commission only calls their paper summonses, so I'm not really worried about it.
Okay, no one's ever raised it.
Yeah.
Okay. I didn't want a 2-year limbo while
No.
somebody adjudicates it up through appeals courts.
No, and by the end of
Because
the year.
summons is much better.
Yeah.
Summons is much better than notice of violation.
And by the-
reasons that the chair said, yes.
And the new hearings division rules, and many of which we're gonna try to make the ECB rules as close to the hearings division rules as we can, subject to the charter provisions. The new hearings division rule says a notice of violation includes a summons and is also a charging instrument, blah, blah, blah. So we're gonna propose making that change for ECB as well.
Thanks, Mike.
So on the front, I'll have somebody research that issue, Rob? Okay, just in case, can't hurt to be. overly cautious. But as of now, what we have on the front is, we will make the summons number more prominent, either move it up to the top if that's feasible from an IT standpoint, or make it bigger in the middle, okay? For the warning, we're going to add language referring to remote adjudications and change the end of the sentence and higher penalties. We're going to actually have to change that to may be imposed because there are some charges that are flat penalties, so the default is actually the same as the hearing penalty.
Yeah, I think maybe imposed is better altogether because once a hearing officer may look at the actual document itself, they may find a defect on its face and dismiss it as a consequence, and nothing may be imposed.
Right.
Unlikely, but it does happen.
All right, moving to the back, I gave you, yeah,
Just
I'm
before,
sorry.
just one quick question just to clarify. So I'm trying to envision what's going to be, when a respondent appears, or is noticed to appear at ECB, or is it going to be
Both hearings division. Both hearings division,
Right,
of which ECB will be a part.
I understand. So our forms in the interim, which I don't believe are long forms, I don't know if you're completely ready for January 1st, that's the end of the year. Should our forms be saying oath, oath,
Hearings division.
oath, hearing, opposite of the hearings division? That's the way our forms should be printed.
Short answer is yes.
Okay, so considering the inventory of forms that we have, the agencies might have a big issue with revamping these forms.
Stickers. That's how we've always done it in the
Well,
past.
stickers are a problem also, right? Stickers are peelable, you can't, you have to have the inspector travel with a bunch of stickers to put on the 3 sets of forms. It is a problem for agencies considering trying to do this quickly.
A lot of this stuff, it really doesn't matter what the, that they use it on the form. So we know where it's going and what it's doing. A lot of this is basically to educate the public as to what's going on and what their rights are. Those rights are not going to change, and where the documents are going, it's really not going to change substantively. Unless you have like 100 billion of these forms that'll last for the next 20 years, they can probably be used until they're used up.
All right, I just beg for more time because I don't think the end of the year is going to be so feasible for the agencies. We have to redo forms in order to get the other inventory amendments distributed again and so on. So
Actually, we order it for most of the agencies.
okay, yes, for these forms, but as you're saying, you're thinking of going along the other agencies that don't use these forms, and so in respect.
Well, this is really more about the electronic
All right.
versions,
All right.
right? I mean,
Okay,
these
so
are the
we have,
templates for
so
the
we have
electronic.
time, then, you're saying, DOP, because we're not putting electronic.
Right.
Okay, thank you.
All right, so anything more on the front? So I gave you a new copy of the back that was, it has one slight change from what was distributed in your package. We added a line above reasonable accommodation that says, to view the law or who you were charged with, go to. And that has the link that's actually on the NewYorkCity.gov website to the laws and rules of the city of New York. So any comments or questions on the back? This is, again, not cures. This is the no cure back.
Well, sorry, Elizabeth Maurer, citizen member. I had one question, actually, I guess it's really a question on the front, but it makes note of it on the back. It says at the top, note, if the charge on the front of the summons state you must appear in person, then you have to appear in person. Where is that going to appear?
That's in the agency real estate.
Okay.
That's up to the agency to make that determination.
And then a very minor thing, but I just feel like it can cause annoyance for some people, is where it says how you can make payment in person. It says checks, money orders, and credit cards are accepted. Given that there's a whole line underneath that, can you note which credit cards are accepted? So people don't show up with a card that's not, I mean, I think UF only takes MasterCard and Visa for parking tickets, for example. So if somebody shows up with Amex, they're gonna have to go out.
Yeah.
So I would just suggest mentioning which credit cards are accepted, so people don't have to go get another form of payment once they've shown up.
Or debit card, for that matter.
Yeah, Joe.
Just for the fire department, just, I mean, it doesn't affect us, but for the reasonable accommodation, it says if you have a disability and require accommodation on the day of the hearing, call the phone number listed below. There's 6 phone numbers listed. So maybe you might want to specify if they have to do the 1844, or if they have to call each one of the individual.
There's no phone
There
number
shouldn't,
for
there
that
should be
individual.
only one phone number. Do you have 6 phone
There's no
numbers?
phone numbers.
Oh, you're right.
Those
I'm
are
sorry.
addresses.
I'm sorry.
There's only one
You're right.
phone number.
You're right, I'm sorry.
Yeah.
I'm sorry.
You scared them.
Yeah.
It's like, wait a minute, was it?
Yeah, no, you're right. Sorry.
Huh?
Tom Spetner is this number. I don't know that it matters, but do we intend to have the vendor multiple offense schedule contained here? I mean, it's just it just sort of sits there as sort of an outlier. I mean,
Well, so this is a form that's going to be used by a lot of agencies. We wanted the back to be uniform. It's actually, for anybody that's using the paper short form tickets now, it's already there. So I think if an agency wanted to take that out on their electronics, I don't think that's a problem as long as it's not an agency that issues vendor tickets.
just
So,
sort of seemed funny that it was
Yeah,
there,
no, I
but I
know.
don't object to it being there, just.
You're right, it looks like it's out of place. The thing is that multiple agencies that issue vendor summonses, such as Parks Department, Police Department, which is popular with the Police Department,
health department.
Health Department, and like that. But the back of the summons is more customizable than the front for agencies, because the idiosyncrasies of different agency rules. For example, you mentioned before the in-person requirement. For reasons I don't understand, the TLC has a lot of rule violation stuff that requires the respondent to appear in person. I'm not sure why, but that's their call, it's their rules. So that piece is customizable because of the idiosyncrasies of their rules. And a lot of the back is idiosyncratic to particular agency operations.
Sorry, Elizabeth Nauer again, but what is the utility of having this here even for an agency that issues vendor violations? Won't they be putting what their penalty, they're charging as the penalty on the front?
It's because
So, I mean, this might be confusing to somebody, like, why is,
So the answer to that is no. Because if it's a multiple offense schedule, then they will write on the front, multiple offense schedule.
and the person has to figure out how much they owe?
Well, they come in and have a hearing.
the problem is that the inspector on the street or the cop on the street who's issuing the vendor the summons has no idea whether this guy's had multiple offenses before.
So
And that's
those
only
wouldn't
something that
be,
they'll, after it goes through the process, when it gets to whoever's presenting the summons at the hearing, we'll have that information.
so those wouldn't be ones that you could just pay by mail?
Actually, they can, the vendors can pay by mail, and some of them do know how many priors they have, and they send in payments, and if they get it wrong, they get a bill.
Or they get a
Or they
refund.
get a refund.
Okay,
We actually give them a refund.
okay, got it.
As much as it horrifies the Office of Management and Budget, we actually give people a refund.
I've just been informed by Amy Slivka, the Deputy Commissioner for ECB, that the
The credit cards can change from year to year or month to month. It depends on the rate that DAP is getting. So if we put in a specific credit card one month or but it might be good for 6 months, they might change the credit cards they're accepting, so it might be difficult to put an exact credit card.
I thought it was a good idea, Elizabeth. Apparently, it's not gonna work.
I thought it was a good idea too.
I do too.
Oh, well. Actually, I think they charge you,
They charge a service fee.
the service fee for using a credit card.
Should it say that then?
You mean that even?
Well, I know it says that when you bring it up online,
Yeah.
and you go
Do they-
around, yeah, it's worth the $2.
Do they charge the service fee?
They do charge us
They
that.
charge a service fee
If
if you
that's-
use a credit card, even if you're paying at the window?
If that's.
I don't know if they pay on the window.
No, yes, they do. I don't know if it's at the window.
Online, they definitely
Online,
charge
they
the service
definitely
fee, and it
do.
does say that.
I guess that sort of leads me to wonder why the credit cards be changed, because if the city's not paying the service fee no matter what it is,
They are paying the service.
They do change. and
Because
the person is paying the service fee.
The
No, the
service, the
city-
service fee is different for different cards, but the city just charges one rate
Oh,
for
okay.
the service fee.
Okay, okay.
Cheaper.
It's somewhere in the middle. There was a big debate about what rate to charge. Okay, so we can't make the change about the credit cards. Anything else about the back? Great.
Some minor things.
Yeah.
Are you,
I just have some minor things, I'll give teeny stuff.
Oh.
I think there's no closed paren after min-max on the vendor multiple events schedule.
Oh, I thought I changed that. Thank you.
There's just 2 or 3, I'll just give it to you.
Okay, okay. Joe?
are you planning to go over the cure session at any point?
Not now, but yeah, when you guys are going electronic, yeah. So,
So wait.
I mean, I sent it to you. If you have comments on it,
I'll send you the
you
comments.
can certainly send it to us, yeah,
Okay.
sure.
You said-
I think you did, yeah.
And you mentioned the long form.
Well, theoretically, if it all works out, and that's something that we have to work through, it'll look a lot like this.
So you haven't created the long form yet? have you?
I have, it's gonna look like this.
Oh,
But it's
okay.
gonna have a lot of different information in the agency real estate because the long form agencies have a lot of different information that needs to be in that agency real estate. But the idea is to have the framework on the outside at least, other than the details, be the same for everybody. So anybody that's getting a ticket will know where they need to look on the ticket for their hearing date. Right?
So because I haven't, you've seen it?
I've seen a version, I think, this is, yeah, I've seen a long form version.
Okay, we haven't identified.
Oh, I thought we sent it to you, but I will send it to you. Okay. So,
With changes we've discussed, is there a motion to adopt this as a prescribed ECB summons? I think it's unanimous. Thank you.
thank you.
I'd like to add, this is an aside actually, but one of the things that we've discovered in reviewing the processes over the last 5 months or so is that even within ECB, tribunal stuff, there are hearing officers that essentially specialize on sanitation summonses and just do sanitation summonses or building summonses or in the other contexts, health department summonses and things like that. Part of what we're doing right now is cross-training all the hearing officers. So all the hearing officers, probably by the end of the summer, will be able to hear summonses issued by any agency. The object of the exercise there being is if you're a small business, we may have health department summons, the sanitation department summons, the buildings department summons. You can go in front of one hearing officer and deal with all of them simultaneously at the same time, rather than having to come at different dates and appear before different hearing officers. because some agencies have higher volume than other agencies, we sometimes have an entire day dedicated to summonses issued from one agency. So if you come in on Buildings Department Day, but you also have a sanitation summons you want to take care of, you're kind of stuck. The idea will be, hearing officer will be able to deal with whatever summonses you have in front of you. And that will also include the hearing officers that are now, we have segregated because of historical legacy anachronisms in doing just the taxi cases or doing health department cases. That's part of the concept of having a consistent hearings division where essentially any summons that's written to any business or member of the public can come and get it taken care of one way or the other. That said, and I'll be glad to talk to anybody about it later. Good old-fashioned request for cease and desist orders by the EP.
Russell DeCunens, Assistant Counsel, DEP. This month, DEP first has a request for a cease and desist order relating to failure to install a grease trap. This is for Giffords Lane Pizza Corp., 15 Giffords Lane in Staten Island. The establishment was ordered to install a grease trap in August of last year. They have been issued a series of notices of violation for failing to comply with that order. They have defaulted on all of those notices of violation, I believe. Did I hit something here? I guess I did.
So we wound up in the atmosphere. It's going to take too long. I think we can continue regardless of the Apple commercial in the background.
Just turn off the screen.
Shut the screen.
Or turn it off.
Yeah, just turn off the screen.
Okay. All right. Actually, I can see the questions pretty intense now that I want to go.
Okay, so yeah, sorry about that. I think I was pretty much done with the first one. Again, they've been ordered to install a grease trap. They have still not done so despite the issuance of several notices of violation, all of which they have defaulted on. Based on the continuing failure to comply, DEP is asking the board to order to issue an order to cease and desist. Yeah.
Doug Swan, citizen member. I'm just curious, how extensive is the grease interceptor? What exactly is it?
What, I'm sorry?
What exactly is the grease trap interceptor?
Oh, okay, so for restaurants, commercial establishments that generate in their normal course of business, what's called FOG, fats, oils, and grease, in order to keep them out of the sewer. It's simply, it's installed on the sink, and it's a grease called the grease interceptor. It intercepts
the plumbing system.
Yeah, it's part of the plumbing system. It intercepts grease before it goes down the drain. Periodically has to be cleaned out, and they have to get a carter to come over and take it away.
Elizabeth Maurer, citizen member, does the department have any sense of why this entity has just defaulted continuously, and has there been
I
any
mean, it's a
correspondence?
corporation, so these tickets would have been served in Albany, and I believe, BWT serves them in addition, either by mail or in person. I don't really have any information specifically on why they're not being responsive.
But if a cease and desist order is issued, it will be served on them in person.
I'm sorry?
If we issue a cease and desist order, it will be served on them in person.
It will be served personally by one of our inspectors, and depending on what the state of the rule is right now, either by certified mail or by regular mail. Okay, so that's it on that one, if we want to do that one separately.
Is there a motion on that? Well, or do you have more?
I have the two other types, so if we want to do them all together, that's fine, or I have boiler ones and backflow ones as well.
Want to accept it? Okay. Is there a motion on this one? It is unanimous with one abstention.
I have 8 requests for cease and desist orders relating to expired certificates of operation for boilers that are still using number 6 fuel oil. The deadline for abandoning or stopping the use of number 6 fuel oil is June 30th, so it's about a month away. There are still people who have certificates that are effective through the end of June. So as certificates are expiring and people are not converting, we are still in the process of issuing NOVs and cleaning up sort of now the last remnants of that population. So we may still have requests for cease and desist orders for a little while longer. But we have 8 this month. These are all locations that have expired certificates to use number 6. They've been issued a notice of violation, which has been adjudicated in violation, and they have still not abandoned the use of number 6 and initiated the process to renew the certificate for another fuel. So for that reason, DEP is asking the board to issue orders to cease and desist in these 8 cases.
Is there a motion? Again, it's unanimous with one abstention. I have a question. Is it illegal for anybody to buy number 6 fuel oil in the city of New York now?
After June 30th, it is not legal to sell it, supply it, or to use it.
June 1st?
June 30th.
June 30th. So after June 30th, we could also, the city could also hit the suppliers if they're supplying.
We would, if we do find buildings that are still using it after June 30th, then we will also find out who's supplying them the fuel, and we will go after the suppliers as well.
Thank you. Okay, Russell, one more follow-up question to that. What's the universe of buildings that are probably still not going to be compliant?
It's down into the low hundreds at this point. I think it's under 300. at this point. Again, some of them still have valid certificates that are expiring in June.
Right.
So those people can keep using it until whatever date, whatever expiration date is on their certificate. And we can't do anything to go after them until after that certificate expires.
Yeah.
So, you know, we will still be issuing tickets in June and July to these people. We would then have to wait for those tickets to be adjudicated before we could do anything in terms of a cease and desist order. So there'll be, again, a residual population that will decline eventually to zero, but it's still going to be a while till we get to
But
zero.
my sense is that you're not going to be able to turn some people's heat off in the winter, all right? And so I'm wondering.
Well, that is one of the problems with the fact that if they made it June 30th, that it expires, because there are people, if you have an expiration date of June 30th and you're just going to not convert, then we can just first issue you a ticket in July, and then by the time that gets adjudicated, we're into the fall sometime, and then, you know, the commissioner is going to have to make a decision on how we go about enforcing those in terms of, you know, sealing people that don't comply when we get there.
Right, and that's my thing, is that, you know, you just, by the time you're ready to do that, it's going to be winter. And I just wondered, number 6 oil are usually huge buildings, right?
A lot of them are big buildings, yeah.
Huge preheaters and all that stuff. It's not so easy to convert. I'm wondering if there's a proactive campaign.
Well, it's not hard to convert to 4. It's really not that big of a deal to convert to 4, which is all you have to do at this point, so. But yeah, that, if we get to the point next winter where we have people that are still using 6, you know, the commissioner is gonna have to decide how we address those, hopefully very few residual cases.
I understand that for some of them, it's just a matter of replacing the burners. And that's it, not the whole boiler system.
But the oil tank, I don't mean to prolong, but the oil tank systems are not.
Usually, if you're converting to 4, you do have to replace the burner. There's a thing that sort of liquefies number 6 that you don't need with other fuels that you remove. But you also do usually have to clean the tank out. And when you clean the tank out, sometimes you find that the tank needs to be replaced, and that's where it can become a big expense. But if the tank is okay, converting to number 4 is not that big of a financial burden. Okay. And finally, we have 28 requests for cease and desist orders for cases where buildings have failed to comply with commissioner's orders to install backflow prevention devices, and notices of violation have been adjudicated. In violation for failing to do that, and the buildings are still not in compliance. So again, we generally have 28 of these every month. So,
Is it the same 28 guys?
no, actually, the backlog is still considerable. We only bring you 28 because in terms of scheduling hearings, that's about as much as the schedule can bear, but we could bring you a lot more than that, which we don't.
All right. Is there a motion? Can I get it unanimous?
Yeah, thank you.
One abstention. I was wondering how popular these backflow preventer guys were.
It's very popular with plumbers.
Request for pre-civil reports?
Good morning, I'm Kelly Corso, Assistant Director of Adjudication for ECB. We had 16 pre-civil reports for the 4. 10 of them pertain to backflow violations. In each of the backflow cases, the hearing officer recommends that no sealing or further action be taken. This recommendation in each case is based on the respondents providing proof that an approved backflow prevention device was installed and tested at the premises, bringing the premises into compliance with the water code. 5 of the reports pertain to air cases. In each of these cases, the hearing officer recommends no further action be taken. This recommendation is based on the respondent providing proof in each case that a valid operating certificate had been obtained to bring the cited premises into compliance with the air code. And the final report pertains to a violation of the noise code. At the hearing, the respondent provided proof that work had been done to bring the cited kitchen exhaust equipment into compliance with the noise code. Based on that proof, the hearing officer recommends that the equipment remain unsealed if the initial reinspection and further re-inspections for a period of 180 days show no violation. That's all.
Motion? It's unanimous with one exception. Thank you. Is there a motion to go into executive session? And we will go into executive session. Thank you. We'll ask the Swiss card to do that. A motion to affirm the appeals decision from May 7th, 2015. I believe it's unanimous. They're affirmed. If anybody hasn't signed the attendance sheet, but I think that's right here. And is there a motion to adjourn? Thank you very much.
Thank you.